appeal in the matter of Gorbachev and others, and EU reflection on
Mr. Mott. Good morning, my lords. I appear with Mr. Stratton for the appellants. My learned friend Mr. Belshaw appears for the first respondent, Mr. Gorbachev.
Yes.
As you know, this is the appellant's appeal in relation to ground 4 of their grounds of appeal. In my submissions today, I'm first going to deal with the relevant legal principle, and secondly, explain why that principle applies to the facts of this case. I'll start by taking the court to the Totalize and Motley Fool case, which is at tab 1 of the authorities bundle. This was a case which concerned Norwich pharmacal proceedings against 2 websites which ran internet bulletin boards. The applicant, Totalize, had been defamed by an anonymous user of these bulletin boards and wished to discover that user's identity. The first instance judge granted the order and also made an order that the defendants pay Totalize's costs of the application. And the second defendant, which was called Interactive, appealed that order. If you go to page 6 of the authorities bundle, I can pick up at paragraph 12, which is the submissions of Mr. Higham, who was the counsel for the appellant, Interactive. He started, as you can see, by taking the court to the observations in the Norwich pharmacal case itself. In particular, he took the court to the observations of Lord Reed, which are quoted there, where Lord Reed said, but there may be other cases where there is much more doubt. The validity of the patent may be doubtful, and there could well be other doubts. If the respondents have any doubts in any future case about the propriety of making disclosures, they are well entitled to require the matter to be submitted to the court at expense of the person seeking the disclosure. The court will then only order a discovery if satisfied that there's no substantial chance of injustice being done. And also, Mr. Higham referred to the speech of Lord Cross, which you can see then quoted immediately below. I think I can pick up at the very last line of page 6 of the authorities bundle, without putting the applicant to the expense of obtaining an order of the court. But then he says, in any case in which there was the least doubt as to whether disclosure should be made, the person to whom the request was made would be fully justified in saying that he would only make it under an order of the court. And then the final sentence of that passage, the full costs of the respondent, of the application, and any expense incurred in providing the information would have to be borne by the applicant. At paragraph 14, Mr. Higham submitted that the principle expressed in those speeches was consistent with CPR Rule 48.1, which was the predecessor to the current Rule 46.1. In other words, he submitted that that CPR provision did not formally apply to his case, but that that rule embodied a more general principle that applies to disclosure applications against third parties. And you'll see, lastly for his submissions, that at paragraph 15, Mr. Higham submitted that a party should be paid the costs in circumstances where, and then you'll see lettered paragraphs A through to E, with which the court will be familiar because I set up that citation in my skeleton argument, that essentially where the party has a genuine doubt as to the applicant's entitlement to disclosure, where the party is under an obligation not to reveal the information or where there's doubt about the position, where there's a risk that proceedings could be brought against the respondent if the disclosure was voluntarily given, where the respondent might suffer damage if he was seen to be providing the disclosure voluntarily, or otherwise had a legitimate interest in not be seen to be providing it voluntarily, or lastly, if the disclosure could infringe a legitimate interest of somebody else. Over at paragraph 17, there was one further submission actually made by Mr. Higham, and I can pick that up at 4 lines through paragraph 17. The submission was that it was wrong to penalise his client in costs for leaving the decision to the court, particularly as Totalize, the applicant, would be expected to recover their costs from Zedust, who's the anonymous user who had made the defamatory statement, as part of the costs of the action that they intended to take. By awarding costs to Totalise, the court had ensured that the proper person, Zedust, could in practice avoid paying those costs. That, he submitted, was contrary to justice. Now, at paragraph 18, Lord Justice Aldous records the submission of Mr. Maloney, who appeared on behalf of Totalise. You'll see the submission which is made, and then halfway through paragraph 18, the court concluded that the general rule on costs cannot apply to Norwich Pharmacal applications. Such applications are not really inter partes disputes to which Rule 44.3 is specifically directed. And then the final sentence, a closer analogy is with applications for pre-action discovery, to which Rule 48.1 applies. In paragraph 19, Mr. Maloney submitted that the judge had a discretion on costs, but about 4 lines down again, the Court of Appeal concluded that the judge failed to take into account the relevant matters. And in particular, in the last 4 lines of that paragraph, the failure to consider the effect upon Interactive of voluntarily disclosing confidential details, and the fact that Totalise could recover the costs from Zedust if they were to bring a successful action for libel. And then, lastly, to turn over to page 10 of the authorities bundle, at paragraph 29, at the bottom of the page, you'll see that, in essence, the Court of Appeal accepted the submissions of Mr. Higham, to which I've taken you. We believe that Mr. Higham is right. Norwich Pharmacal applications are not ordinary adversarial proceedings, where the general rule is that the unsuccessful party pays the costs of the successful party. They are akin to proceedings for pre-action disclosure, where costs are governed by CPR Rule 48.3. That rule, we believe, reflects the just outcome and is consistent with the views of Lord Reid and Lord Cross. And then, carrying on from the next sentence, in general, the costs incurred should be recovered from the wrongdoer rather than from an innocent party. Although, of course, at the bottom of the page, they say each case will depend on its facts, and in some cases it may be appropriate for the party from whom disclosure is sought to appear in court to assist. In such a case, he should not be prejudiced by being ordered to pay costs. And then at paragraph 30, the court, in my submission, effectively accepted and set out again the submissions of Mr. Higham about the 5 cases, again lettered A to E, which the court says, to pick up 4 lines down, there may be cases where the circumstances require a different order, but we do not believe they include cases where, and then the court sets out the categories A to E that Mr. Higham had identified. And then lastly, to pick up paragraph 31, that does not mean that a party who supports or is implicated in a crime or tort, or seeks to obstruct justice being done, should believe that the court will do other than require that party to bear its costs, and, if appropriate, pay the other party's costs. And that paragraph 31, in my submission, is helpful because it gives some indication of the sort of circumstances that the court was thinking of, which might require a different order to what the court was considering would be the usual one, namely that the respondent's costs of the application would be borne by the applicant. It's not a comprehensive statement, but you get a flavour, I think, from paragraph 31 of the sort of situations in which the parties might be left to bear their own costs, or even more severe, the respondent should bear the applicant's costs. So that is the Totalise and Motley Fool case. There were 2 more cases I wanted to take the court to, one very briefly. The very brief one, first of all, was to the Miller Brewing Company case, which is at tab 3 of the authorities bundle. And I'm going here. Sorry, I should say that the paragraphs 29 and 30 of the Totalise case I've just taken you to were approved by the Supreme Court in the Cartier International case. The reference to that is at paragraph 18, sub 2 of my skeleton argument. So to Miller Brewing, and again, I'm only going here to draw your attention to one particular paragraph which the Supreme Court has subsequently approved. This was a trademark infringement case where the applicant had commenced a second action against various parties seeking delivery up and destruction of some infringing beer. The first defendant was the Harbour Company, which had custody of the beer. It didn't oppose the application, but it sought its costs. And if you go to page 45 of the authorities bundle, you can see paragraph 29, Merseydoc set out the basis on which it sought costs. And you'll see from the second half of that paragraph that the claimant resisted that costs order. And then paragraph 30, the court applies the approach from the Norwich Farmable case, and starting from the third line. The logic behind the general rule is that where an innocent third party has reasonably incurred legal costs to enable a claimant to obtain relief, then, as between the innocent third party and the innocent claimant, it is more unjust if the innocent third party has to bear his own legal costs than it is for the innocent claimant to pay them. After all, it's the claimant who's invoking the legal process to obtain a benefit, and the fact that the benefit is one to which he's legally entitled is not enough to justify an innocent third party having to be out of pocket. And again, that paragraph was approved by the Supreme Court in the Cartier case, and the reference for that is paragraph 19.1 of my skeleton argument. And then the last authority that I wanted to take you to was the one at tab 5 of the authorities bundle, and that's the SES contracting case. This was a pre-action disclosure case. In brief summary, the application was made by SES Contracting, which was a third-party tunnelling and mining company. SES had previously provided a significant level of those services to the respondent UK Coal. In 2005, there was a tender where SES was beaten by UK Coal's in-house subsidiary, a newly set up in-house subsidiary. And there was evidence that SES's own former chief executive, Mr. Weston, had leaked details of SES's tender to UK Coal and had been conspiring with UK Coal against SES. So this was a case where there was believed to be a good claim against the respondent directly. If you go to page 64 of the authorities bundle, paragraph 11, you see therefore halfway through para 11, there were provided grounds for thinking that the SES might have a claim against UK Coal. At paragraph 12, you can see the application was resisted by UK Coal, which filed a number of witness statements, and Mr. Weston filed a statement too. Paragraph 13, you can see from the first line that the hearing took the better part of 3 days. The judge made the order for disclosure, and then he ordered UK Coal to pay SES costs of the successful application, and UK Coal appealed. At paragraph 16 over the page, you can see, starting from the end of the third line, that Counsel for UK Coal drew our attention to the terms of Rule 48.1 and submitted that, provided he does not act unreasonably, a respondent to an application of this kind is entitled to require the applicant to justify his claim by resisting the application as he thinks fit, without being at risk on costs. And then attention was drawn to the Bermuda International case in support of the submission that the court has never gone further than ordering the respondent to an application of this kind to bear its own costs. Paragraph 17, going over the page to page 67 of the authorities bundle and starting about 6 lines down. Although a respondent to an application may incur some costs merely in considering what response to make to an application of this kind, in most cases he will only incur substantial costs if he opposes it. By laying down a general rule that the respondent will be awarded his costs, therefore, I think that the rules implicitly recognise that it will not usually be unreasonable for him to require the applicant to satisfy the court that he ought to be granted the relief to which he seeks. And just pausing there, in my submission you can see that the reference to satisfying the court, the applicant satisfying the court, includes a situation where the respondent is not merely neutral, is not consenting but not opposing, but includes a situation where the respondent is positively opposing the application but is unsuccessful in doing so. And then to pick up where I left off, the reason for that, if it be necessary to find one, lies, I think, in recognition that a private person who is not a party to existing litigation, which brings with it an obligation of disclosure, is entitled to maintain the privacy of his papers, unless sufficient grounds can be shown for overriding it, and that it is for the person seeking to invade that privacy to justify doing so. Then, just to show you the way it was dealt with, over the page at paragraph 21, starting at the second sentence, if it was reasonable for UK Coal to oppose the application at all, it was surely entitled to decide on what basis and with what evidence it wished to do so, provided only that it did not take a wholly unreasonable course which unnecessarily increased the costs. At paragraph 24, you will see a submission by Mr. Bayard for the respondent, that the court concluded that the judge did fail to have sufficient regard to the general rule. That's in the first 4 lines of paragraph 24.
Well, on the facts, they found that
on the fact,
the respondent to the application had behaved unreasonably in the way it had listed, and the result was no increase to costs.
Quite right, my lord. Yes, exactly right. The judge's decision was reversed, but was replaced with an order that each party bear their own costs. Yeah. Yes, quite right. On the basis of those authorities, the appellants respectfully submit the learned judge in this case fell into error by failing to apply the applicable principle, which is, in my submission, that a non-party resisting a disclosure application is entitled to its costs, even if it has been ultimately unsuccessful in resisting disclosure, so long as it has behaved reasonably. And pausing there, it is worth noting that Melinda Friend's skeleton argument does not actually, in my submission, engage with that case. Melinda Friend's skeleton argument is at tab 4 of the core bundle.
We finished with the authorities now, haven't we?
I have, yes, so as I said, tab 4, bundle page 47 of the core. At paragraph 2, the central issue facing the court is whether the costs of the trustee's failed jurisdiction application fall within the general rule in CPR Rule 44.2, or, 4 lines down, or the specialist rule in CPR Rule 46.1. And the same binary characterization is found in paragraph 6 and 11, and in particular 12, where 3 lines from the bottom, it said that the central issue at the heart of this appeal is whether the costs of a failed CPR Part 11 application fall within the scope of the general costs rule or within the scope of the specialised cost rule in CPR 46.1. But that is not the case set out in the grounds of appeal, and it's not the case set out in my appeal skeleton argument. And it's not the case the trustees ran below either. Our case, rather, is that the jurisdiction challenge made by my clients falls within a general principle of which Rule 46.1 is certainly an example, but the principle is of broader application, as is shown by the cases relating to Norwich Pharmacal applications, which do not fall within Rule 46.1, but nevertheless, the authorities demonstrate that there is a general principle which is justified on the basis of the various points I've taken you to in the authorities. And it's that general principle on which we rely front and foremost of our.
Do you say it does fall within 46.1?
If necessary, then I say it falls within 46.1. It falls within the breadth of the words of the application at the end of Rule 46.12a. But my primary case is that I don't need to go that far, because there is a general principle at work here which sits alongside Rule 46.1 and its particular wording. So turning then to the present case, in circumstances where the jurisdiction of the English court was at the very least unclear in this case, if not doubtful, my client's reasonable but unsuccessful jurisdiction challenge falls within the scope of that principle. And I say that for two main reasons. First, the starting point is that my clients are non-parties to the underlying litigation. It is Mr. Gorbachev who has chosen to involve them. Applying the analogous approach in the authorities I've just taken you to, if Mr. Gorbachev has any entitlement to his costs, then the just approach is for him to recover them from the defendant, Mr. Guriev, in the underlying litigation. I pause here to note that learned friend Skeleton argument sought to query whether that was actually possible as a matter of the rules and procedure. I don't need to take you there, but if you'll note, that's paragraph 14 of learned friend Skeleton argument, where he said it was far from clear that the costs of a third-party disclosure application could be recovered between the parties to the main litigation. Learned friend's concern is misplaced. I wasn't proposing to take you to the authorities that show that, but because they're not referred to in my skeleton, because it predated learned friends, I'll give you the note for it. The first case is at tab 4 of the authorities bundle. It's a case called Anglos and Kent. Page 58 of the authorities bundle at paragraph 6. And there Mr. Justice Lindsay was considering making the costs of a third-party disclosure application the claimant's costs in the case, in other words, in the main proceedings, but ultimately reserved those costs to the trial judge of the main claim. And obviously, either one of those courses involves the costs of the third-party disclosure application being borne by one of the parties to the main claim. And the second case that we found, which demonstrated that this could be done, is tab 11 of the authorities bundle. It's a case called Hotel Portfolio 2 UK Limited. It's page 217 of the authorities bundle. It's paragraph 54 of that case. It's a case of Mr. Justice Foxton. And he held there that the costs of an application under section 236 of the Insolvency Act could be costs incidental to the main proceedings and therefore recoverable in those main proceedings. And an express basis of Mr. Justice Foxton's decision was an analogy that he drew with third-party disclosure applications under CPR Rule 3117. So the learned judge regarded it as plain that the costs of a 3117 application could be recoverable in the main proceedings. So that deals with learned friend's response to that first point about where the costs of the application should most justly lie. My second point is that the present case satisfies all 5 of the criteria that I showed you in Totalize and the Motley Fool earlier. And for your reference, I deal with this at paragraph 22, sub 2 of my skeleton. In short, my clients in this case had a genuine and reasonable doubt that Mr. Gorbachev could make his disclosure application against them here in England, rather than...
Is there any evidence of that? Is there evidence from a trustee saying, I had a genuine and reasonable doubt about jurisdiction?
My lord, there's no evidence to that. There's no evidence of the state of mind of my clients. In my submission, one can see from the fact the application was made that they believed that they were,
That doesn't follow at all.
Well,
I mean, you can say objectively it was there was reasonable doubt whether the court had jurisdiction because there was a legal point to be decided, which was perfectly well arguable, and it was argued and decided against you. But that doesn't mean it wasn't arguable. But if we're in the subjective area of somebody having a genuine doubt or believing that they're under an obligation of confidence and so forth, there simply isn't evidence about that. And it's not surprising there isn't evidence because this was just a jurisdiction application. It wouldn't be relevant to jurisdiction whether somebody had a doubt about the point, they just argue it. It wouldn't be relevant to jurisdiction whether they were under an obligation of confidence. That might be relevant when when the court gets to the substantive application, if there is jurisdiction, but it wouldn't matter at the jurisdiction stage. So there wasn't evidence, and since this only goes to the costs of the jurisdiction application, in a way it's not surprising that there wasn't evidence. So how is the court to deal with that situation, applying these 5 factors, if they're what has to be applied?
Well, in my submission, my lord, it's not usual in my submission for a respondent to put evidence of whether of their subjective state of mind or their subjective concerns in response to the application before the court. If a respondent, for example, simply resisted an application on the basis that the order was too broadly drawn, one could, in my submission, make the same point. Well, that doesn't tell you anything about whether, in fact, the respondent has been advised and, let's say, knows that this is a bad point to take. But nevertheless, those sorts of points can be made on a 3117 challenge, and in essence, the objective reasonableness or otherwise of the points being made is treated by the court as reflecting the likely subjective state of mind of the person making them, which in my submission is perfectly proper and acceptable, because otherwise unnecessary evidence of the particular concerns enlivening a respondent would be put before the court simply to justify what is meant to be the general rule in any event, which general rule is not stated to be subject to evidential proof of any particular sort by respondents. So thus in this case,
well, there where you've got the general rule, if you're within 46, you can say, well, that's the general rule. It's for the other side to displace it. But if you're relying on something which is your primary case, apparently, which is not 46 but some more general principle, then you've got to bring yourself within that general principle, haven't you?
well, my lord, I don't wish to accept that with respect. The general principle for which I'm contending is one which reflects and sits alongside 46.1, and, for example, is evident in its application to Norwich Pharmacal applications. If the general principle applies, and the points taken by a respondent are not objectively unreasonable, then that general rule applies and the respondent gets their costs. So, on a Norwich Pharmacal application, a respondent does not have to put in evidence asserting that they have only innocently become mixed up in wrongdoing, or evidence asserting any particular state of mind at all. In my submission, what the court does is look at the reasonableness of the points actually made, considers whether they're well-founded or ill-founded. But if ill-founded, it weighs up the way in which the points made and the way in which they were taken, and reaches an objective conclusion on reasonableness. And in my submission, that's what the court should do in this case on the jurisdiction challenge, which I accept is formally a different stage of the third-party disclosure application. But the substance and reality of the situation is that my client's jurisdiction challenge was just one of the reasonable bases on which they resisted the disclosure application being made.
Can I just ask you one point on that specific bit? I well understand why, if you're the innocent holder of documents and you're met with a very wide request, you're perfectly entitled to get legal advice, perfectly entitled to come along and make all the proper points. This is too wide, it's a fishing expedition, all the points that might be made. But if you launch a jurisdiction challenge, isn't that, and this is, as I see it, really what the judge was saying, isn't that really something of a completely different order? And if you win on it, excellent, well done, and you'll get your costs. And if you don't, it's all at your own risk.
My Lord, my response to that, I think, would be it very much depends on the circumstances of the case and the particular jurisdiction challenge. This was a particularly unusual case where the jurisdiction challenge being made was apparently well-founded. Indeed, to turn the position around, this was a case where His Honour Judge Pelling KC, who made the order for permission to serve out, the application had been made to him orally and ex parte due to a change of instructions by counsel, a change of the instructions to counsel Gorbachev halfway through the hearing. I intend no criticism whatsoever of those counsel. They were put in a very difficult position. But the fact remains that the only case which was on point of this issue, which was the Nix case of Mrs. Justice Cockrell, was not cited to him. So the only case on point which says you can't do this was not cited to His Honour Judge Pelling KC. And I don't think he was told that this has never been done before, but as Mr. Justice Jacobs held in his first instance judgment, it had never been done before, but in this particular way by reference to Gateway 20 of Practice Direction 6B. So in circumstances where, with respect, His Honour Judge Pelling KC appeared to have made his order on an erroneous basis, the submission from Mr. Gorbachev is effectively that the only way that the appellants could bring that issue out, could test that issue, was at risk on costs. Was, you know, as a matter of form, they had to make a Part 11 jurisdiction challenge, but effectively what they were doing was ensuring that this issue was properly ventilated. And in my submission, looking at the substance of the matter, that was a perfectly reasonable thing for them to do. And it's applying the general principle that I've taken from the authorities, that can reasonably and sensibly be characterised as a reasonable basis for opposing a third-party disclosure application. Now, in another case, the position having been settled by your Lordship's judgment, if another respondent in our shoes were to take the same point over again on a jurisdiction challenge, one might well say, well, that's hopeless, it's been decided, that's always clear. But in the somewhat unusual circumstances of this case, in my submission, the jurisdiction challenge falls within the general principle that I've submitted. I should pause. I hope that answers your Lordship's question.
Thank you very much.
We fall within, in my submission, each of the 5 points, A to E, that one extracts from the Motley Fool case. My clients were in the position where this comes onto the issue, I believe, raised by my Lord Justice Mayles through his clerk last Thursday, which essentially queried the basis on which the opposition had been advanced, and on that, I mean, of course, you've had the written submissions from both sides.
Yes, thank you both, by the way, very much for producing those at fairly short notice. We're grateful.
Thank you. It's always helpful to know what particular concerns the court has before the hearing. So it's a welcome guidance. My clients are trustee companies. The natural persons who are their directors are particular individuals who are professional solicitors in Cyprus at a firm founded more than 30 years ago, which has many clients other than the parties involved in these particular trusts. They owe, as set out in my written submissions, they owe duties both to Mr. Gorbachev as one of a class of discretionary beneficiaries, but also to the protector of the trusts, Mr. Mariashin, and to the set laws. And in those circumstances where my clients are in the middle of a relationship between people who have fallen out and who may have opposing interests, but my clients are reasonably entitled to take the position that they did.
Well, you assert that they owe the duties of confidentiality. Can I just try and unpick that a little bit? First of all, was this an argument that was even canvassed before the judge, whether there was or wasn't a duty of confidentiality?
It was not, my lord.
And was the material upon which you're now basing it, which is what I understand has been produced in response to my Lord's email, was that before the judge when he was considering costs?
The trust deeds and their associated documents, such as their letters of wishes, were, I believe, in the bundles before the judge. Certainly on the first instance jurisdiction hearing before Mr. Justice Jacobs, so they were available to the judge.
But were they referred to? Were they relevant to the jurisdiction, the substance of the jurisdiction application? I wouldn't imagine they were.
No, they weren't, my lord.
So there's no reason for the judge when he was considering costs, even to have had the terms of the trust deeds in mind. He may not. They might have been in the bundles, but there's no reason for him to have made himself aware of them.
No, that's fair, my lord. Right. That's fair.
And then you assert that that we should look at that material. Why so?
My lord, my submission is this: the issue of confidentiality and the duties that my clients did or did not owe, and to whom they owed them, was really not an issue at all before Mr. Justice Jacobs, from either side. In my submission, the reason it wasn't an issue was because it doesn't go to the issue of jurisdiction, nor is it particularly relevant and material on the substantive application of 3117, because if there's a duty of confidentiality, it can be overridden by an appropriate order of the court. So for that reason, neither side, I believe, thought it particularly pertinent to set the trustees' obligations of confidentiality before the court and analyse them, because...
I understand that. I'm just seeking to explore how it is that you say you can establish the 5 factors in Motley Fool, which a number of which are dependent on your argument that it would have been a breach of confidentiality to disclose voluntarily, when that material wasn't before the judge. Was the burden on you to establish that, so far as your argument in this court is concerned?
If I need to establish an underlying proposition, such as that my clients owed a duty of confidentiality to person X, then I must accept the burden would be on me to establish that, because he who asserts must prove.
And when you say to person X, it would have to go at least as far as showing that in relation to the documentation which was being sought, there was a duty of confidentiality to somebody in respect of at least part of that documentation. Is that how you put it?
Well, in my submission, the court can proceed in a slightly less granular way. In my submission, the court can take into account the fact that my clients are trustees. The evidence was put before the court to the effect that there is contested and outright litigation between, on the one hand, at least the protector of the trusts, Mr. Mariashin, who I believe has been repeatedly named in Cypriot proceedings as a defendant to allegations of breach of trust there. And on the other hand, there was Mr. Gorbachev as one of a class of discretionary beneficiaries. And in my submission, the court can take into account that situation and recognise that the position of my clients as trustees is one where they may realistically be exposed to competing demands.
May won't quite do, will it, for your argument?
Well, I mean, in my submission, the court can take account of the commercial situation and the inherent likelihoods of the situation. That's my first point. My second point is that I believe I'm right in saying that Mr. Gorbachev himself hasn't evidenced or even asserted prior to last Friday that each of the other members of the discretionary class of beneficiaries have supported his application. They're members of his family, true to say. But I believe my learned friend's submissions last Friday said it was axiomatic that they supported the application. I believe it's a matter of an axiom because it's never been asserted or evidenced prior to last Friday in those submissions. My third point is that the 5 numbered propositions in Motley Fool, A to E, they're not, in my submission, cumulative. They are any of them individually is capable of supporting in principle the costs order for which I contend. And just looking at them again. So I'm at paragraph 30 of Totalised. So first tab of the authorities bundle, page 11 of the authorities bundle.
So you say A will do.
Yes,
and that doesn't depend on confidentiality.
Quite right, my lord. A will do, and that doesn't depend on confidentiality. Indeed, B is engaged not just where there's proof of an appropriate legal obligation, but it's also engaged where the legal position was not clear or the party had a reasonable doubt as to the obligations. C is the party could be subject to proceedings if disclosure was voluntary. D is the party would or might suffer damage by voluntarily giving the disclosure. And E is the disclosure would or might infringe a legitimate interest of another. So the type of factors which are being set out in Totalize, firstly, are not expressed at the level of proving to the civil standard of proof. But secondly, in my submission, that rather reflects the fact that the Court of Appeal in that case was not envisaging that evidence would be served or would usually be served to establish any of these particular propositions, rather that the court would take a more general approach to the case as it appeared to them, as it's been fought on the substance, and would determine costs in that light.
But even if the test is might, and perhaps leaving aside the point that none of these points were made to the judge, what is the damage that the trustees might suffer, or what are the proceedings to which the trustees might be subject? I mean, we simply would be guessing, wouldn't we?
Well, my answer would be that the trustees might be subject to proceedings from the protector or set laws, but I accept your lordship's point, which is that there is no evidence before the court as to that concern or as to the likelihood of that. So I do accept that point on the evidence. But that would be.
And I'm not criticising the fact that there is no evidence. It would have probably been disproportionate to spend thousands of pounds on getting evidence of Cyprus law on a point which was only going to go to the costs of the jurisdiction application. But we are where we are, so I'm just wondering how far we can take these 5 points.
I think my submission is that when the court is dealing with matters of costs, following on from an application which may have been considerably shorter than the application in this case, in my submission the court can proceed by reference to a more general and less granular analysis of what the concerns objectively might have been, and infer that from particular points taken on the substance, rather than requiring, as you say, evidence to be served, evidencing these propositions, which might well, in many cases or most cases, be disproportionate to the sums at stake or to its utility to the court.
Right, where do we go on your submissions now?
Well, my lord, we're almost through. My final point was to make submissions briefly on the reasonableness, the objective reasonableness of the point taken in front of Mr. Justice Jacobs. As I've said, the only decision on point was the Nix case, where Mr. Justice Cockrell had determined there was no such jurisdiction. And if you'll note, that's at tab 10 of the authorities bundle. In particular, her paragraph 17, where she concluded that an application for third-party disclosure did not fall under Gateway 20 of Practice Direction 6B. And at paragraph 23, she said that in any event, it would be inappropriate to circumvent the letter of request procedure. and of course, Mrs. Justice Cockrell is the author of the leading academic commentary on precisely these issues. Mr. Justice Jacobs accepted at first instance in this case that the questions which arose before him had been determined in Nix. And for your note, that's his judgments at tab 4 of the supplementary bundle. It's page 31 in particular, paragraphs 8 and 9 of his judgment. He accepted at his paragraph 28 that there was no previous authority which had held that Gateway 20 could be used to permit service abroad of a third-party disclosure application.
Well, I mean, speaking for myself, and of course I have the advantage of having heard all the arguments, which my colleagues didn't. For my part, I wouldn't need persuading that there was a reasonable argument to be had. And indeed, I think we put the case on a slightly different basis from Mr. Justice Jacobs.
Well, I'm grateful for that indication, my lord, because it may be that I don't need to spend...
Colleagues would want to hear
Can I, because I wasn't there, just ask you this, because I've obviously had the advantage of reading my lord's judgment, but at paragraph 83 and 84 of the original judgment, he made the point that the documents, whatever had been said in other cases, in this case the distinguishing feature was that the documents were always here, and therefore were always subject to the jurisdiction of the court. And that might have seemed, when the point has been made, obvious, and therefore less than reasonable to pursue the point as a jurisdiction challenge.
Well, my lord is certainly correct that that particular feature of this case was certainly one which led to the conclusion that, for example, it wasn't an inappropriate circumvention of the letter of request procedure.
The 70 convention, yeah.
Yes.
Yeah.
I hope I'm fair in submitting that whether or not that point was the determinative point is one of these things which can only be concluded in retrospect by reading your lordship's judgment. Prior to your lordship's judgment, the matter was expressed in relatively unequivocal terms by, for example, by Dicey, in a passage from Dicey which post-dated Mr. Justice Jacobs' judgment, and I footnoted that in my skeleton argument. So I think my response to my lord is that, notwithstanding that particular feature of the case, which I fully accept was very important in the ultimate analysis, the way in which it had been analysed by others nevertheless gave rise to perfectly reasonable arguments on the point.
And may I ask just one follow-up question from that, which is, if that analysis is right, which is it was reasonable to argue this at first instance, and you got permission to argue it on appeal because there was a real prospect, so it's reasonable to ask it on appeal, why shouldn't the submissions you make about costs now have applied to the costs before the Court of Appeal last time?
Well, the response to that is that the costs of the ground of appeal that we're dealing with today doesn't encompass the costs of the Court of Appeal, and we're not seeking on this appeal to disturb the order that was made by my lordships last summer. So the consequences of the appeal that I'm advancing today would be confined to the first instance application before Mr. Justice Jacobs.
I understand that, but that's not really an answer to the question of why the principle shouldn't have applied.
Well, I think there are two answers to that. The first is that one can see that there is a distinction between persisting in a point on appeal and taking that point which arises out of a first instance judgment before another first instance judge. So that would be my first point. There was a difference of at least degree, if not reasonableness of approach, in taking the point first and then persisting in the point second. And that is a sensible basis for distinguishing between the two costs orders. But my second answer is that the logic of the general principle I've been articulating before you today would have applied equally to the costs order made by your lordships last summer. And I'm essentially on this appeal submitting that the general principle is as I've articulated it today.
Well, whether or not it would or might have applied, my recollection is that nobody suggested that it would apply to the Court of Appeal costs, and that nobody submitted, for example, that we ought not to deal with the costs of the appeal until ground 4 had been resolved. I know you weren't there, but perhaps Mr. Stratton and Mr. Belshaw could have a think and either confirm that or tell me differently.
I believe I'm right in saying that nobody suggested the costs of the appeal should be deferred because they would, that they could logically be analysed at the same time as this ground we've been discussing today. I believe I'm right in saying that. I believe that the parties' written submissions to the court, and of course they were purely brief written submissions, I believe that they canvassed some but not all of the points and authorities which have been in issue on this appeal. So there was perhaps I can say so that there was a partial treatment of these issues.
We were certainly alive to the point because we had to decide whether to give permission on ground 4, and we did. But my recollection is that, and I think you're confirming it, is that nobody said that if it was a good point, it applied equally to the costs of the jurisdiction appeal.
I believe that is certainly right. I believe that nobody said that the same point would arise equally on this appeal. Perhaps they had in mind the particular distinction that I was addressing earlier. But I believe the court was, I think, taken to or pointed towards in brief written submissions some but not all of the materials which are before the court today.
All right, thank you.
I don't believe I have anything else, but I'll just check with my man junior. That's all right. My learned junior reminds me that, that there was a statement in our written consequential submissions that the same principle applies.
Oh, was that?
Yeah, apparently so. But perhaps without the full elucidation to which your lordships have been treated on this appeal.
Well, it has been a treat.
Unless I can be of any further assistance.
Thank you, Mr. Martin. Mr. Belshaw.
My Lords, you're asked to determine a short-pointed principle in this appeal, namely, what is the correct starting point for the award of costs in respect of a failed jurisdiction challenge, where that arises in the context of a separate and underlying application for non-party disclosure. Is it the general rule under CPR 44.2 that the losing party pays? The learned judge at first instance, that was his instinct, and in my respectful submission he was correct. Or is it the specialist rule under CPR 46.1 or some other general principle which finds its home in CPR 46.1? Those are the issues that your lordships are faced with today. Now, the main focus of my submissions this morning will be to take you back to first principles, because in my submission that is what this appeal is really about, and that is where you will find the answer. You will not find any authority which is directly on point. As I will come on to show you, the authorities that my learned friend relies upon do not assist on this appeal. My overarching and primary submission will be that issues of jurisdiction, including those which arise in this case, are both substantively and procedurally distinct from the separate underlying claim or application in respect of which the court's jurisdiction is invoked. And it therefore follows in my submission that questions of costs do not fall within the scope of Rule 46.1 or some other general principle to similar effect, but instead they fall within the scope of the general rule in 44.2. And I'm going to develop that submission in 3 parts. First, I'm going to look at substance and procedure. Second, I will explain how this sits with the language of Rule 46.1 and the purpose that lies behind that rule, and indeed behind any broader general principle which my learned friend posits. And third, I will briefly address the cases in which the trustees rely to show your lordships that they do not offer assistance on this appeal. I do have a secondary submission, which is that whatever the correct starting point, whether we are starting with 44.2 or 46.1, the destination is the same, and the trustees ought to be ordered to pay my client's costs. My Lords, before I delve into those submissions, I think it might be helpful just to set the scene in terms of the precise application that the learned judge was concerned with at first instance. And we can pick that up in the additional bundle of documents that was submitted with my skeleton argument, with my additional submissions last week. I believe my learned friends have prepared a composite bundle, or I don't know if you have.
Yes, it looks as if we all have that.
I'm grateful. If we could turn, please, to tab 4. These were the additional documents that accompanied my further submissions. And the pagination at the lower right hand of the page, if we can turn, please, to page 134. This was the trustee's application notice, which gave rise to the application before Mr. Justice Jacobs at first instance. And we see here that they applied for an order to set aside His Honour Judge Pelling Casey's order for service out of the jurisdiction, and the reasons for that in the box below the word because, permission to serve the original application, the amended application, and any other documents in these proceedings out of the jurisdiction on the trustees in Cyprus should not have been granted because applications for third-party disclosure under Section 34 of the Senior Courts Act 1981 and CPR 31.17 do not fall within CPR Practice Direction 6b, paragraph 3.120. So in other words, they did not fall within the scope of Gateway 20 for service out of the jurisdiction, and there was also a challenge to the court's order for alternative service. Now, the trustees amended their application by way of letter to add another ground of challenge. That is at page 140 of this bundle. I'd like to pick it up at paragraph 18. These were the grounds on which the trustees now advanced that they sought to challenge.
Sorry, I missed the page number.
Sorry, it's page 140.
Thank you very much.
So this was a letter application to amend their application notice. They added a new ground of challenge, which is at paragraph 18b, which is essentially that if the court did have discretion to permit service out of the jurisdiction, it should not exercise it in favour of doing so. So, my lords, what we had was an application brought by way of a separate application notice challenging the court's extraterritorial jurisdiction on two bases, the first being gateways and the second being discretion. This application was not concerned with the merits of the underlying application for non-party disclosure, and my learned friend has accepted in his submissions that there was no evidence before the court to deal with that underlying application. It's true that documents were in bundles that were available to the judge at first instance, but none of that evidence was relevant to the application that he was concerned with there. And of course, the hearing of the underlying and separate non-party disclosure application was still some months away, and when that would happen and whether the trustees would be party to it was all dependent upon the outcome of their jurisdiction challenge. Now, my lords, against that background, I'd like to turn to the first part of my submissions, which is the question...
Sorry, can I just ask you to pause there? That was a matter of case management, but one might have a case, for example, where the documents are sought shortly before trial, whereas a matter of case management, jurisdiction and substantive matters are heard together. Would that involve any different considerations?
Well, my lord, in my submission, as I'll come on hopefully to show your lordships, any time the court does consider its extraterritorial jurisdiction, that question is always considered as a preliminary issue. It does not engage with the substance of the underlying application. Now, there may be circumstances where there are case management grounds or determining the preliminary issue of jurisdiction and then going on to say, okay, I've determined the jurisdictional question now, I will go on to determine the substantive underlying application. But those are two different applications. and one necessarily comes before the other in my submission.
Well, does it? I mean, one of the jurisdiction questions is there a serious issue to be tried on the merits? And it may be that even if in a single hearing the matters are being dealt with together, they would be dealt with all together in a hearing in which the issues were jumbled up, if I can put it that way, so that it wouldn't be a question of deciding, in any sense, one before the other.
Well, my lords, in my submission, when one's looking at the jurisdictional inquiry, you're quite right that there is a question as to a serious issue to be tried, but that is a low threshold. It's a very different threshold from what the court would be considering when it comes on to consider the substance of the underlying application or claim between the parties. And so there may be circumstances where it's all jumbled up together, and in effect the court does consider it all together. But as a matter of principle, jurisdiction challenges are separate and distinct in my submission from the underlying application, and the thresholds when it comes to merits are different. And I hope to...
It would probably be unusual to deal with both matters together, unless perhaps there was no objection to it, because usually when a party is resisting jurisdiction and fails, it is given an opportunity not to take further part in the proceedings on the merits, for example, by not filing a new acknowledgement of service or whatever it would have to do, so that it has the choice under the rules to let the proceedings go by default.
Indeed, my lord, and I think quite right, that illustrates the point that jurisdiction challenges are a preliminary inquiry and they are separate and distinct from the underlying application. Of course, there are circumstances in which it may all be jumbled up together, but that is quite an unusual circumstance in my submission, and it was not the circumstance that Mr. Justice Jacobs was faced with at first instance in this case.
Okay.
Thank you.
So, my lords, the first part of my submission is that the questions of the court's jurisdiction are substantively and procedurally distinct. In my submission, when considering any or at least most jurisdiction challenges, including in particular the trustee's jurisdiction challenge in this case, the court is only concerned with whether it is jurisdictionally proper to bring the separate underlying claim or application against the respondent, and it is the applicant, in this case Mr. Gorbachev, through his act of service, which gives the court the basis for the exercise of its jurisdiction. It's not a jurisdiction which the court assumes for itself, it's all dependent upon the act of service. And so when considering any jurisdictional challenge, the court must ask itself two essential questions. The first is whether its jurisdiction has been properly invoked, and that's looking at the act of service. And the second is whether it should exercise its jurisdiction to determine the substantive underlying issue between the applicant and the respondent. The court does not at that stage, ordinarily, concern itself with determination of that separate underlying claim or proceedings. And one can readily see that from Mr. Justice Jacobs' judgment, in this case, as I'll come on to show you, and one can also see it from the Court of Appeal's judgment, rejecting the jurisdiction appeal. And I would like to just point out a passage from that judgment at this stage. It's in the Authorities Bundle, tab 12, page 258, paragraph 99, final paragraph.
I'm so sorry, could you give me the reference again?
Sorry, it's Authorities Bundle, tab 12, page 258, paragraph 99. Final would be the final page of that tab. Where my Lord Justice Mail said this: they would dismiss the appeal. The court has and should exercise jurisdiction in this case. Whether an order for third-party disclosure should be made will be a matter for the commercial court to decide. So, in my submission, we see that on any jurisdiction challenge, and in particular in respect of the trustee's jurisdiction challenge in this case, the court was concerned with the existence and exercise of its jurisdiction only, and those are matters of the utmost importance, and it has historically been understood that summoning a defendant before the English court involved an assertion of sovereign authority, There are still some proponents of that view. Professor Briggs is perhaps the chief proponent of that view, but the Supreme Court tells us that times have moved on, that the conceptual basis for the existence and exercise of the court's extraterritorial jurisdiction is no longer exorbitant, it's no longer about an assertion of sovereign authority, but the modern focus of the jurisdictional inquiry is said to be a pragmatic one in the interests of the efficient conduct of litigation in an appropriate forum. And that's what Lord Sumption and the other members of the Supreme Court have said in the Abela case. In other words, the entire focus of the jurisdictional inquiry is to determine where the merits of the separate underlying dispute between the parties ought to be heard, not to engage substantively with that underlying dispute itself. So whichever conceptual basis one prefers in my submissions, questions of the court's extraterritorial jurisdiction are of the utmost importance. And in view of that, the existence and exercise of the court's jurisdiction are rightly treated as freestanding substantive issues, which are separate and distinct from the underlying proceedings in respect of which the court's jurisdiction is invoked. And jurisdiction isn't necessarily prior inquiry in my submission, because were it otherwise, it would defeat the entire purpose of the modern law of jurisdiction according to the Supreme Court. Because one would then be going on to determine the merits when the entire purpose of the jurisdictional inquiry is to determine where those merits should be heard. I would like to show your lordships how Dicey puts this, if I may. That's in the authorities bundle at tab 15, page 265. This is Dicey in the conflict of laws. Right at the outset of that academic work, Dicey says this at paragraph 1004. The questions that arise in conflict of laws cases are of three main types. First, has the English court jurisdiction to determine the case? He then goes on to discuss choice of law and recognition and enforcement of judgments. I'll pick it up again at the final sentence where Dicey says this. The law of every modern country has rules dealing with these questions called conflict of laws in contrast to its domestic or internal law. And so what Dicey is saying here, my lords, is that jurisdictional rules fall conceptually within that body of law known as the conflict of laws, and that sits separately and distinct from domestic law rules which apply to the substance of the party's dispute. Dicey then goes on in paragraph 1005 to discuss jurisdiction, and I'd like to pick it up where the marginal note is, with it's about towards the end of the sentence beginning thus: in the English conflict of laws, questions of jurisdiction frequently tend to overshadow questions of choice of law, or to put it differently, it frequently happens that if the question of jurisdiction, whether of the English or the foreign court, is answered satisfactorily, the question of choice of law does not arise. So, my lords, what Dicey is saying there, I accept he's dealing with choice of law rather than underlying substantive law, but in my submission what Dicey is saying is that jurisdiction, even within the conflict of laws, is a necessarily prior inquiry, and once it is determined, it is often determinative of the other issues which might arise. And in particular, it is the most important question within the conflict of laws. And the fact that jurisdictional rules are separate and freestanding from domestic rules isn't just a matter of academic theory, but in my submission it is one of the fundamental features of the conflict of laws in this jurisdiction. And the jurisdictional rules and their development of separate and freestanding rules reflects in my submission a conscious and deliberate effort by courts at the highest level to keep jurisdictional questions separate from substantive rights under domestic law. And I'd like to show your lordships how Professor Briggs deals with this in his book, Civil Jurisdiction and Judgments. That's at tab 16 of the authorities bundle, page 270. And at the top of this page, Professor Briggs sets out a development of the jurisdictional rules of common law. It really took off during the 1970s, and I think what he's really talking about there is the doctrine of forum conveniens, developed in the Spiliada case. And he comes on to say this, picking up at the marginal note, the sentence beginning, the result was. The result was and is that as a matter of common law, it is necessary but no longer sufficient to catch up with one's defendant and serve process upon him. Though this service gives the court jurisdiction in a technical sense, if the defendant disputes it, that is, he takes the step necessary to dispute the jurisdiction itself or the appropriateness of its exercise, the court must rule on the jurisdictional issue, and may rule in such a way that the claimant is left with no practical alternative to bringing his case before the courts of another country. In other words, the result of the conscious development of the common law rules of jurisdiction is that jurisdiction is to be determined as a separate and preliminary issue, because if the jurisdiction challenge succeeds, the English court lacks jurisdiction or power to determine the merits, and those merits will not be considered by the English court, but may go off elsewhere. And of course, as my Lord Justice Mail said, even if the English court does have jurisdiction, the respondent or defendant may decide that they wish to take no further part in those proceedings. And one can readily see the practical utility of that approach, because if the jurisdictional inquiry was anything other than a preliminary inquiry, a challenge to the court's jurisdiction may well amount to a step in the underlying proceedings, and that may well amount to a submission which would defeat the very purpose of the jurisdiction challenge itself. So as a matter of principle, jurisdiction is separate and distinct from the underlying claim or application. And we can also see that to be true as a matter of practice. And one can see that in almost every case on jurisdiction which come before the English court. In every such case, the court concerns itself with the jurisdictional inquiry and not with the determination of the underlying claim, or at least where everything may be jumbled up together, it will determine the jurisdictional issue first before then going on to determine the underlying claim. And we'll come on to look at how that happened in this case when I take your lordships through Mr. Justice Jacobs' judgment. But first, it's worth bearing in mind the three questions which the court must ask itself in a jurisdiction challenge. They're cited at paragraph 8 of my skeleton argument, and I don't think they are controversial. First, is there a good arguable case that the application falls within one of the gateways for service out? And we saw that the trustees raised arguments about this in their jurisdiction challenge. Second, in relation to the foreign respondent to be served with the application, is there a serious issue to be tried? And we saw that the trustees did not challenge jurisdiction on this basis. Third, in all the circumstances, is England clearly or distinctly the appropriate forum, and ought the court to exercise its discretion to permit service out of jurisdiction? And again, we saw that the trustees raised arguments about this. So in this case, the court was not concerned with merits arguments at all, even to the standard of serious issue to be tried. But where the court is concerned with merits arguments, it is only concerned with them to the extent of that very low threshold serious issue to be tried, and not to substantively engage with the underlying claim or application between the parties. It does not conduct a mini trial. It's only concerned with the jurisdictional issue. And I would like to show your lordships just how Mr. Justice Jacobs dealt with this in his judgment. I know your lordships have read it, so I do hope to be brief and provide signposts rather than going through it in detail. It is in the supplementary bundle at tab 4. And I would like to pick it up, please, on page 31. At paragraphs 5 to 7, we see the issues with which Mr. Justice Jacobs was concerned. Paragraph 5, he was firstly concerned with whether the application under Section 34 of the Senior Courts Act and CPR 3117 fall within Practice Direction 6B, Gateway 20. That's the gateway issue. At paragraph 6, secondly, if the court does have jurisdiction, is this case one in which it is appropriate for the court to exercise its discretion to serve out? That's the discretion issue. And thirdly, was it appropriate to order service by alternative means? Now, over the following paragraphs, the judge outlines the factual and procedural history. And then he says this at paragraph 16 on page 33. There have thereafter been various procedural debates. The upshot of them is that I am presently only concerned with the trustees' jurisdictional objections, which have been advanced in writing through the oral submissions of Mr. O'Leary, the claimant's principal argument, namely that the application can be made against Forsters in any event, has yet to be determined. Whatever the outcome of the present application, directions will need to be given for the future conduct of the substance of the CPR 31.17 application, whether against Forsters alone or against all respondents.
I think the position is that there was no issue before Mr. Justice Jacobs about serious issue to be tried on the merits, although it was a point to which Judge Pelling addressed his mind and said he was satisfied about that.
Yes, my lord, that's correct. But in my submission, what Mr. Justice Jacobs was saying at paragraph 16, he was saying that he's only concerned with jurisdictional objections, and within that, the scope of those jurisdictional objections, I've shown you that the trustees did not raise merits arguments. But what he says in the final sentence of that paragraph is that whatever the outcome of the jurisdiction application, directions would need to be given for the future conduct of the substance of the CPR 31.17 application. So in my submission, this amply demonstrates that the learned judge was treating the jurisdictional issue as entirely separate from the substance of the underlying 31.17 application. And indeed, we see that throughout the remainder of the judge's judgment. I'm not going to go through it all, but the judgment was only concerned with looking at the jurisdictional objections. As my Lord Justice Males will know, it raised issues of whether an application for non-party disclosure under Section 34 of the Senior Courts Act was a claim for the purposes of CPR Part 6, whether it gave rise to proceedings for the same purpose. It looked at whether Section 34 allowed proceedings to be brought, particularly against persons who were not within this jurisdiction. And the reason for that was entirely because it was a requirement of the gateway. It was a requirement of Gateway 20 that the relevant enactment allowed proceedings to be brought outside the jurisdiction. And so that was the only reason why the learned judge was considering it at all. And we see the same story when we get to the Court of Appeal, if I may respectfully say so. The Court of Appeal's judgment deals with precisely the same issues. It looked only at the jurisdictional inquiry. It considered whether there was a claim, whether there were proceedings, and whether Section 34 allowed proceedings to be brought outside the jurisdiction, all solely as part of the inquiry into Gateway 20. So the questions in this case were only concerned with gateways and discretion, not with the merits of the underlying application for non-party disclosure. That was reflected in the judgments of Mr. Justice Jacobs and indeed the Court of Appeal, and again it was reflected in the costs order of the Court of Appeal. If I remember correctly, my Lord, there were no reasons given for the Court of Appeal's costs order, but it was not suggested that the costs of the appeal fell within the scope of Rule 46.1 or any general principle which my learned friend now seeks to advance. So drawing those threads together, as a matter of both principle and practice, questions of jurisdiction are in substance different from domestic law questions which arise from the separate underlying application between the parties. But jurisdiction in my submission is also procedurally distinct. And English procedural law does make a conscious decision to separate matters of jurisdiction from the underlying proceedings. And if a defendant or respondent wishes to challenge jurisdiction, they must do so by way of a separate application notice, and that will be a separate application. And that's precisely what the trustees did in this case. And the trustees, in my respectful submission, have no answer to all of this. You weren't addressed on it this morning by my learned friend, but they do raise some points in their skeleton argument. Paragraphs 22 and 24 of my learned friend's skeleton argument, he advances an argument which is essentially segregating the costs of the jurisdictional inquiry from costs of determining the underlying third-party disclosure application is to focus on form over substance, and that this is all essentially a quirk of English civil procedure, is what I take from the skeleton argument. Now, my lords, that's not the case for the reasons that I have explained. Jurisdictional rules are in substance different, and treating the jurisdictional inquiry as procedurally distinct represents, in my submission, a conscious and deliberate decision by the Rules Committee in the exercise of its statutory powers and functions. It's not something that can be dismissed as a mere quirk or as a matter of form over substance. The trustees also adopt a slightly different approach at paragraph 26 of their skeleton argument, where they say that there is no principled reason to distinguish between the court's territorial jurisdiction and its separate domestic law jurisdiction under CPR 31.17. But, my lords, the fact is that the law does draw that distinction, and as I had explained, there are strong reasons of principle for that. And again, that was recognised in my submission by both the judge at first instance and by the Court of Appeal. And it follows, therefore, in my submission, that the costs of the trustees' separate and distinct jurisdiction challenge fall within the general cost rule in CPR 44.2. And that brings me on to the second part of my submissions, which is to look at the text of Rule 46.1 and the purpose which underlies that rule, and indeed any broader principle for which my learned friend contends.
Can you, just before you go to the second bit, can I ask you this, which is, if you're right and it's a separate part and 44.3 applies, where do you factor in the fact that they are an innocent third party? Fine, they've taken a point they shouldn't have done, but they've only been dragged here because they're an innocent third party. Wouldn't it be fairer not to make them pay all the costs, perhaps make no order for costs if they're unsuccessful?
My lord, in my submission, it wouldn't be the right outcome. And as I understand it, the trustees, it would be perfectly possible for a judge exercising their discretion as to costs under the general rule to take that factor into account if it was a good one. But the trustees do not challenge the exercise of discretion at first instance. Instead, they say the learned judge applied the wrong principle and started from the wrong point. So there is no issue of was the judge's discretion under Rule 44.2 wrong. I think my learned friend must accept that if we are within the realms of CPR 44.2, that is the end of the appeal, because they do not challenge the exercise of the judge's discretion. And indeed, in my submission, that is a sensible approach, because his exercise of discretion is beyond reproach. So, in my submission, it would be possible to take those matters into account if they were good matters to be taken into account. But again, in my submission, the jurisdictional inquiry is separate from the underlying application, so there's not really a question about innocent third parties being dragged into it. An innocent third party is perfectly able to come before the English court and say, I don't want to give this disclosure, or I take no position on it, but I want the court to make an order on it. There they are an innocent third party to the disclosure application, but the position on a jurisdiction challenge is different, because they're saying, I don't even want to be before the English court, whatever the merits of the underlying application.
But why is that different in practice? Of course, I understand your points on the difference between merits and jurisdiction. But if the question ultimately is addressed to me as a third party, should I give this disclosure? Why should it be different if I say I shouldn't give it because the English court simply shouldn't be dragging me there, or I shouldn't give it because even if I should be dragged there, there are reasons of substance for not giving it? Why should there be a distinction between those two kinds of cases?
Well, my lord, there's a distinction because the jurisdiction challenge really raises no issue of substance, in my submission. What the third party there is concerned with is whether or not they give disclosure. And so the jurisdictional inquiry is separate. They are not concerned with protecting the privacy of their papers, for example, at the jurisdictional stage. And the fact that they are an innocent third party, perhaps, who's been dragged into the dispute, I accept that that is a factor which is highly relevant to the non-party disclosure application, but in my submission, not for the purposes of the jurisdiction challenge. But even if I'm wrong about that, and it is a factor which can be taken into account in the exercise of the court's discretion under CPR 44.2, then the court may perfectly well do so and come to whichever decision it thinks right in the exercise of its discretion. And that issue does not arise on this appeal because there is no challenge to Mr. Justice Jacobs' exercise of discretion under 44.2.
Suppose.
But as I understand Mr. Mott's submissions, I think there is a chapter that says it may come within 46.1, but even if it doesn't, there is a question of principle, and for that reason, he ought to recover his costs. Now, whether you characterise that as a challenge to exercise of discretion, it is, as I understand it, an argument that irrespective of whether we come within 46.1, as a matter of principle, the trustees ought to recover their costs.
My Lord.
And if 46.1 doesn't apply, well, it'll be the general principles under 44.
My Lord, with respect, I'm not sure that is how the trustees have advanced their appeal, certainly not how I had understood it. And if I can show your Lordships the ground of appeal of which you're concerned, it's in the core bundle of tab 2. Ground 4, it's on page 33. And the ground of appeal is this. The judge erred in his approach to the incidence of cost by applying the general test that costs follow the event. The court should have applied the specific principle that the third party resisting third party disclosure application will be entitled to their costs, even if they challenge the application and that challenge is unsuccessful, either directly or by analogy. So in my submission, how I had always understood it, the trustee's position on this appeal was one of principle. What is the correct starting point for the award of costs? It was not, in my submission, a question about whether the judge had correctly exercised his discretion if we do find ourselves within the general rule in 44.2.
Suppose you have an innocent third party who wants to maintain the privacy of his documents and he's out of the jurisdiction. But it's clear that because the documents he's got are highly relevant, and all he can say is, well, I just don't want to give them. They're my documents and they're private. But it's clear that the court would make an order on the merits if it gets there. So his only chance of resisting the application and preserving the privacy of his documents is to challenge jurisdiction, on which he's got an arguable but ultimately unsuccessful point. Why should he not be in CPR 46 territory in that situation?
Because, my Lord, in that circumstance, what's happening is that one is jumbling up jurisdictional question with the question of the substantive underlying relief. And if they do want to maintain the privacy of their papers, that is a factor which the cases show arises on the underlying substantive application. But it's wrong to roll that up into a general principle and extrapolate backwards to a jurisdiction challenge, which is a separate and distinct application, which raises separate and distinct issues. It's not concerned with maintaining the privacy of anyone's papers. It's solely concerned with a party trying to prevent themselves from being brought before the English court. And that is, in my submission, a separate and distinct inquiry made by way of a separate and distinct application.
Okay, you want to take us to the language of CPR 46?
My Lord, yes. And my submission here is that treating the cost of the jurisdictional challenge as separate and distinct from the cost of the underlying non-party disclosure application is consistent with Rule 46.1. I have two submissions to make in this regard. The first looks at the text of the rule, and the second looks at its rationale. It might be helpful if you all have a copy of the white book to have it to hand. It is at page 1604 of the white book. And subrule 1 provides that this paragraph applies where a person applies. What we are concerned with is subrule B for an order under 1 section 34 of the Senior Courts Act 1981. Subrule 2 then goes on to provide that the general rule is that the court will award the person against whom the order is sought that person's costs, A, of the application, and B, of complying with any order made on the application. And subrule 3 provides for a derogation. The court may make a different order having regard to all the circumstances. And there are two particular circumstances listed there, one of which is whether it was reasonable to oppose the application. And in my submission, the application to which the general rule in subrule 2 refers can only be the application as listed in subrule 1. And in our case, that is the substantive underlying non-party disclosure application. In my submission, on a plain reading of the rule, it does not and cannot extend to the costs of a separate application challenging the court's extraterritorial jurisdiction. It must be limited to the substantive application which is referred to in subrule 1.
You say it's separate, but if the jurisdiction application is successful, it is dispositive, isn't it, of the disclosure application?
Well, my lord, it may be, but the questions for the court at the jurisdictional stage, as I hope I've shown your lordships, is different from the question which arises on the underlying application. And Rule 46.1 is directed, in my submission, only to the underlying application and the very specific principles which apply and the purpose that underlies this rule, which I'll come on to address in a moment. But we see that it is a specialist rule which relates to the application itself for non-party disclosure. In my submission, it does not extend back to what is a prior inquiry into the court's extraterritorial jurisdiction. They are separate applications, they raise separate issues, and there are separate principles which underlie each of them.
But not separate if decided one way, because one determines the other if decided one way.
Well, if the jurisdiction challenge is successful, then the underlying application never comes to be determined, but that doesn't tell one what the correct scope of the rule in 46.1 is concerned with. My submission is that the plain text of the rule, reference to the application, can only be to the application as listed in subrule 1, and the application that we are concerned with is the application under Section 34 of the Senior Courts Act. Now, the jurisdiction challenge is a separate application made by way of a separate application notice, and although in some circumstances it may mean that the court does not go on to consider the underlying application in any detail, that does not mean that the cost of a jurisdiction challenge falls within the scope of the text in Rule 46.1 in my submission.
If for some reason nothing is said about the costs of an unsuccessful jurisdiction application at the time, and the case then proceeds, and an order is made that the respondent gets the costs of the application, would that include the jurisdiction costs? And if not, why not?
In my submission, no, my lord, because they are the costs of a separate application, which raises separate principles and is a separate inquiry. Jurisdiction, in my submission, is a preliminary inquiry. It must be determined first before anything else. And just as the court in any trial might divide up issues of costs by relation to issues which arise, so too, if costs are not determined at the time of the jurisdiction challenge but left over to another date, the court should, in those circumstances, approach each application separately, because they are, in my submission, separate applications which give rise to separate considerations, and the cost rules which apply to each are different. But even if one gets to a situation where the costs fall to be determined at the same time, the costs of each application are separate and ought to be determined by reference to separate principles. hope that answers your Lordship's questions.
Yes, thank you.
So now what I'd like to turn to is the purpose which underlies Rule 46.1, and indeed the purpose which underlies any general principle on which my learned friend relies, which, as my learned friend has shown you in the SES contracting case, is all about maintaining the privacy of one's papers. And in my submission, the jurisdiction challenge did not concern the question of maintaining the privacy of papers at all, and I hope I've addressed that in answering your Lordship's questions. The application where the trustees did in fact seek to maintain the privacy of their papers was the substantive underlying non-party disclosure application itself, which was heard by Mr. Justice Robin Knowles, CBE, in November of last year, and it will be heard again by another commercial court judge in May of this year when they hear the slightly amended disclosure application brought by my client. As your Lordships may have picked up in the papers, the application before Mr. Justice Robin Knowles was unsuccessful only on the ground that it was too broadly drawn. The judge gave permission to amend the application, to narrow it, and to restore it. And that's precisely what has happened. And that application is due to be heard in May of this year.
That's my fault. I'm not quite understanding why you say that the jurisdiction challenge didn't involve seeking to maintain privacy in the papers. If it had been successful, that would have been the result.
But, my Lord, in my submission, the jurisdiction challenge was solely concerned with preventing the trustees from having to participate in or to engage with the substance and merits of the underlying non-party disclosure application, where they would in due course be seeking to maintain the privacy of their papers. So it was entirely to do with preventing them from coming before the English court, and it was not aimed at maintaining the privacy of their papers. There is a link.
Even though that would have been the result if the challenge had been successful.
My Lord, I can't escape the fact that there is a link between the two, but the application challenging the court's extraterritorial jurisdiction was not in substance an application which sought to maintain the privacy of the trustees' papers. That may have been an incidental result if the jurisdiction challenge had been determined one way or the other.
Well, not incidental, perhaps desired.
But desired, my Lord, but in my submission still, it does not bring one within the scope of the purpose which underlies Rule 46.1, or the general principle on which my learned friend relies, which is solely concerned with the substance of the disclosure application itself, and not with questions of the court's extraterritorial jurisdiction, where the inquiry is significantly different, and there are strong reasons of principle for that.
But surely the purpose of resisting jurisdiction is not simply because that's fun to do in itself, but because you don't want to have to disclose your papers.
My Lords, I accept that's correct, but in my submission that does not amount to seeking to maintain the privacy of one's papers within the meaning of the purpose which underlies the rule in 46.1, or the general principle on which my learned friend seeks to rely. Of course, the trustees did not want to come to England, but in substance, the jurisdiction challenge was all about the court's extraterritorial jurisdiction. It was not in substance concerned with issues about confidentiality or privacy of one's papers.
Right.
So, my Lords, drawing those threads together, in my submission as a matter of substance and procedure, questions of the court's territorial jurisdiction are distinct, and that means that the starting point is Rule 44.2, not Rule 46.1, or any general principle which underlies that, and that is consistent with both the express words of Rule 46.1 and with the purpose which underlies that rule. Now, the trustees' arguments do simply seek to treat everything as part of a single inquiry, and in my submission that is wrong. It is contrary to basic principles and contrary to the express words of Rule 46.1 itself. And that brings me on to the cases on which the trustees rely. I hope to be able to deal with these relatively shortly, because in my submission we do not offer any assistance on this appeal, which is concerned with the costs of the jurisdiction challenge, as opposed to the costs of the underlying non-party disclosure application itself. So first, the trustees rely on a string of cases relevant to the cost of a Norwich Pharmacal application, and were taken to totalise example, yet that case was not concerned with service of a Norwich Pharmacal application out of the jurisdiction, nor was it concerned with the costs of a failed challenge to the court's extraterritorial jurisdiction. And indeed, it was not until very recently that Norwich Pharmacal applications could in fact be served out of the jurisdiction. That only happened in October of last year when the Rules Committee introduced a new gateway for service out, namely Gateway 25. That is not at issue in any of the cases which the trustees rely on. Instead, those cases, what they're concerned with are the costs of the Norwich Pharmacal application itself. And therefore, to the extent that the trustees can draw any analogy with the present case, it is with the costs of the underlying non-party disclosure application and not with the costs of their jurisdictional challenge. Because that wider submission falls foul of the basic principles which I've addressed your lordships on this morning. The same is true of the SES contracting case that my learned friend took you to. This was a case concerned with pre-action disclosure. Again, it was not concerned with service out of the jurisdiction, nor was it concerned with the costs of a failed jurisdiction challenge.
I mean, if that's your point, that applies to all the cases, doesn't
Well,
it? This question, which we have to decide, simply hasn't
Indeed.
on the same facts.
Indeed, my lord. That's the short point. The cases relied on do not help your lordships to answer that question, because they are only concerned with the separate underlying application and not with the cost of the jurisdiction challenge.
But what about, what about the point of principle, which is they're innocent third parties and should therefore be protected in costs?
My lord, that principle applies, I accept, when one comes to the substance of the underlying application for non-party disclosure. But as I've explained in my submission today, my starting point is that jurisdictional applications are in substance different. They are concerned with different questions. Really, the purpose of seeking to protect innocent parties is all about maintaining the privacy of their papers. As I hope I answered your lordship's questions in my submission, the jurisdiction challenge is not in substance seeking to maintain the privacy of one's papers. It is a separate and distinct inquiry which raises separate and distinct issues.
Thank you.
Just briefly, picking up on my learned friend's point that costs can be passed on to the ultimate defendant at trial, namely Mr. Gorbachev, in this case. My lords, that is to put the cart before the horse. Again, it does not deal with the preliminary question of what the starting point is for the award of costs, whether we are within the territory of CPR 44 or 46. And in any event, the cases in which the trustees rely do not bear the weight which my learned friend seeks to place upon them. The Anglos case on which my learned friend relied, perhaps if we back up, the authorities bundle of tab 4. It is a short judgment. It only runs to 6 paragraphs. And in this case, the respondent to the application did not resist the application. We can see that at paragraph 2 of the judgment. Paragraph 3, we see that it was in fact the defendant to the underlying proceedings who resisted the application in that case. And it was those factors which led to the conclusion in paragraph 6, where Mr. Justice Lindsay said this: "It seems to me that it would be wrong in the circumstances to deny the claimant cited this material, which the third party does not oppose." So, my lords, this was a case in which the third party did not oppose the application. It was in fact the defendant in the underlying proceedings who opposed the application, who caused the costs to be incurred. And in those circumstances, it's perhaps not surprising that Mr. Justice Lindsay made the order which he did, to say that the defendant may ultimately bear the costs of that when it comes to trial. And in the Ruhan case, that is it, tab 11 of the authorities bundle. paragraph 54, which is on page 217. And my learned friend referred you to this paragraph. I'd just like to show your lordships how the reference to 31.17 came about. I'd like to take it from about halfway down. There's a single word at the end of the right-hand side, the. The sentence reads, the purpose of such applications, this is under section 236, is very similar to that of applications for third-party disclosure under CPR 31.17, subject access requests under the Data Protection Act, which are an increasingly common feature of litigation, or Norwich Pharmacal applications. Subject to issues of reasonableness and proportionality, I do not see why costs of these kinds incurred for the purposes of litigation are not capable of being costs incidental to that litigation. And then he goes on to discuss the position under section 236 in more detail. So again, this was not concerned with the jurisdictional question, but in any event, the reference to CPR 31.17 was by way of analogy only. It was not a point, it seems, that had been argued. And in my submission, it cannot be the basis for a proper basis for the submission that my learned friend has made, that all of these costs can be passed on to Mr. Gorbachev in any event.
In a straightforward Norwich Pharmacal case, the authorities seem to assume that if the claimant has to pay the third party's costs, he'll be able to recover them from the defendant to the proceedings, the wrongdoer. And that must be on the basis that those costs would constitute costs of or incidental to the claim. What is the distinction in principle in a case in which a party is seeking third-party disclosure under 31.17? Why would they not be costs of and incidental to the claim?
My lord, I don't put the point too highly. I accept that they may well be, but what I'm saying is that the position is unclear, and I think that's the position that's the point I made in my skeleton argument that my learned friend referred to when I said that it was far from clear that the costs of a non-party disclosure application could be passed on in that way. The point is simply that there is, as far as I can see, no authority which is directly on point. Of course,
what's the argument that they're not? Right, what would be the argument that they don't constitute costs of or incidental to the claim?
Well, my lord, I don't want to speculate on that now. It's a point that Mr. Gorbachev may seek to raise in due course at trial. There may be arguments about it, and I accept as a matter of principle it's perhaps difficult to see why they shouldn't be. My only point on this was that it's not clear, there's no authority as I can see that's directly on point, but in any event, you have my submission about putting the cart before the horse, because this case does not deal with the preliminary question of jurisdiction. It does not help your lordships to determine whether costs of a jurisdiction challenge fall within the scope of Rule 44.2 or fall within the scope of the rule in 46.1 or some other general principle, because it only deals with the costs of the underlying application for non-party disclosure and not the costs of the jurisdiction challenge. So in my submission, my lords, the judge was correct to approach the question of costs from the starting point of Rule 44.2. And as I understand it, the trustees, as I have said, do not challenge discretion, and so that's the end of the matter if your lordships are with me. But if I'm wrong about that, and the correct starting point is instead Rule 46.1, as the trustees contend, then in my submission we end up in the same place. That brings me to my secondary submission.
Yes, is this point open to you? There's no respondent's notice saying that if the judge was wrong, then we still get the costs.
Well, my lord,
I make that point because you just, as it were, made the same point against Mr. Mott.
Well, my lord, the appellants seek to overturn the first instance judge's decision and say that the starting point is in fact Rule 46.1. But if we are in Rule 46.1, that doesn't tell your lordships what the correct order for costs should be. Costs in those circumstances are at large, and it is a matter for your lordships to decide what the correct order for costs is. And looking at the text of the rule, that we see that the general rule is that the party against whom the order is sought should be entitled to their costs, but it is open to your lordships to derogate from that. Sub-rule 3 provides that the court may make a different order having regard to all the circumstances. And so if we do find ourselves within 46.1, then that is a matter for your lordships as to what the correct order for costs ought to be. And we saw in Rule 46.1, sub-rule 3, that the court may make a different order having regard to all the circumstances, of which reasonableness is only one that's specifically listed. In my submission, it's clear from the express words of the rule, which direct the court to have regard to all the circumstances, that reasonableness is not the only touchstone for departure from the general rule in sub-rule 2. In the ordinary run of cases, perhaps, unreasonableness will be the case where costs will most likely be ordered, a different order of costs may be made, but it's not the only case in which it would be appropriate for the court to make a different order. So in my submission, I do not need to say that the trustee's jurisdiction challenge was unreasonable, although I do in fact say that, and I'll come on to develop that submission in a moment. But in my submission, irrespective of the reasonableness or otherwise of their application, the circumstances of this case amply justify the departure from the general rule. And those circumstances include that the costs were incurred in the context of disputing the court's extraterritorial jurisdiction without any arguments on the merits. And even if those factors do not mean that the correct starting point is Rule 44.2, though that's my primary submission, those factors are strong reasons to depart from the general position under Rule 46.1, sub-rule 2. And even though I don't need to show in my submission that the trustee's application was unreasonable, I can show that to be the case in fact. And in this regard, the trustees draw attention to the case of Totalese, and my learned friend has addressed you on the 5 factors that you can see in Lord Justice Aldous' judgment. And it's worth having that to hand, because I do want to run through them briefly. It's in the Authorities Bundle, tab 1, on page 11. This is paragraph 30 of Lord Justice Aldous' judgment, and he sets out the 5 factors, 5 cases where the court does not believe that an order should be made against the respondent to a Norwich Pharmacal application. First, in my submission, one cannot simply, one does not simply say that one of these factors will do in staving off costs order against the respondent to those applications, to a Norwich Pharmacal application, or indeed to a non-party disclosure application. The trustees have made a submission to that effect today, but in my submission that would be to turn these factors into a rigid straitjacket from which the court could not depart, and in my respectful submission that's not what Lord Justice Aldous intended here. Rather, these factors should be seen as guiding principles, and the court should at all times have regard to all the circumstances of the case. So in my submission, it's not simply a case of one will do. The court should have regard to all the circumstances.
They are expressed as alternatives: A, B, C, A, B, or C, or D, or E.
They are, my lord, but in my submission, to treat them as simply being alternatives, which, if one is satisfied, costs could never be ordered against a respondent to such an application, would be to turn these guiding principles in my submission into a straitjacket, and it would be unjust in particular cases. The court ought to have regard to all the circumstances. There may well be cases in which it is plainly unreasonable for a party to have taken a position, and that ought to be taken into account, and one should not read these as rigid, as a rigid straitjacket, but as general principles that guide the court in the exercise of its discretion. So, turning to the factors, factor A, where there was a genuine doubt that the person seeking disclosure was entitled to it, and one can see from the language which is used that the inquiry is about substantive entitlements to documents which are sought from the underlying application for disclosure.
Well, there's no doubt at all now, is there? You weren't entitled to the disclosure you sought because Mr. Justice Robin Knowles has said so, and you don't challenge his decision. So we don't have any difficulty with that one, do we?
Well, my lords, my first point here is that the factor is concerned with the disclosure, which is sought by means of the underlying non-party disclosure application, but it's not concerned with whether it was whether there was doubt about the question as to whether the English court had extraterritorial jurisdiction. I accept that these principles may be applicable to the costs of the underlying non-party disclosure application, and my lord is quite right that that has been determined by Mr. Justice Robin Knowles, but that is separate from the cost of the jurisdiction challenge. And what factor A is getting at here is not an issue of jurisdiction, but about whether the person seeking disclosure was entitled to the disclosure. The court's not asking whether the respondent to an application which has been served out of the jurisdiction was entitled to resist the jurisdiction of the English court, or whether they were reasonable in doing so. It's all directed to the underlying application for disclosure. So that being the case, in my submission, it does not come into account at all. But even if it does, the circumstances of this case, as to whether Mr. Gorbachev was entitled to the underlying documents, I accept that Mr. Justice Knowles has determined that he was not, but the trustee's position has always been that Mr. Gorbachev could or should obtain documents from them in Cyprus, through some route in Cyprus, or through the Hague Evidence Convention. And so it follows that their position must be that Mr. Gorbachev is entitled to some form of disclosure, albeit not disclosure under CPR 31.17. And we can see that, for example, in Forster's letters before the trustees became involved. In the supplementary bundle at page 171, which is at tab 21. The three numbered points where the trustee, where Forster say that their client is Ms. Haradimou as a trustee of the Citizens Trust, and the paragraph below that, we remain of the view that an application against this firm as opposed to our client is appropriate. However, we are currently conducting a process of identifying those documents which our client may be willing for us to disclose on the pragmatic basis that such documents would likely be ordered to be disclosed if your client applied as he should in Cyprus. And I don't put the point too highly, my lords, but what I do say is this, that the trustee's position, giving instructions to Forsters, may have been that Mr. Gorbachev was not entitled to documents he sought in England by way of the 31.17 application, but he was entitled to some form of disclosure, or would have been. So, to the extent that Factor A looks at the substantive entitlement to documents under one basis or another, my submission, trustee's position must be that he did have an entitlement under some basis, albeit not 31.17.
I think we might be reading quite a lot into this letter. Anyway, there we are.
Factor B, my lords, this is where a party was under appropriate legal obligation not to reveal the information, or where the legal position was not clear, or the party had reasonable doubt as to their obligations. Now, the trustees seek to split this into two parts. First, they focus on the existence of an appropriate legal obligation not to reveal the information, and they take that as one element. And then they say, second, where the legal position was unclear or where there was a reasonable doubt as to the position. And they seek to split it up in that way in order to argue that the legal position in respect of service out was unclear, and so to bring themselves within the ambit of at least one part of factor B. But in my submission, that is the wrong approach, and one cannot split factor B up into that way. In that way, the entire factor is concerned with obligations not to reveal information, or where there is uncertainty or doubt as to those particular obligations. And viewing factor B in that way, one can take it together with factors C and E, on which the trustees rely, namely voluntary disclosure could expose the disclosing party to proceedings, or would or might infringe a legitimate interest of another. And this was the issue on which the court asked for additional submissions, and I've set out my client's position in those submissions. The short point is that the idea that the trustees owe some relevant obligation of confidentiality or may be exposed in some way is a mere assertion which has only come to light on this appeal in order to bolster their case before this court. There is no evidence to support the assertion, whether evidence of fact or evidence of Cypriot law. And it's common ground that this is a question for Cypriot law. Indeed, it's telling in the context of the Cypriot proceedings that I referred to in my written submissions that Ms. Haradimou and First Link had sought an order restricting Mr. Gorbachev's use of documents disclosed to him in those proceedings on the grounds that they were, quote, confidential and very important. Now, they offered no evidence for that to the Cypriot court, and it was rejected. And one can see that in Mr. Pardy's fifth witness statement. That's in the additional bundle of documents. Again, if we could go please to tab 4. Page 115. Paragraph 4.11.1. Here, Mr. Pardy discusses Mr. Gorbachev's application for disclosure of documents in Cyprus. And he says, on 30th of July 2019, before providing copies of the disclosed documents, firstly, Ms. Haradimou and Mr. Mariashin applied for an order prohibiting Mr. Gorbachev from using the disclosed documents in any other proceedings in Cyprus and or in any other jurisdiction and or for any improper and or collateral purpose without permission of the court or consent of the applicants. In support of this application, Ms. Haradimou asserted that disclosed documents were confidential and very important in nature, in that she wished to prevent these documents being disclosed to third parties, amongst other things. The court dismissed this application after finding that the respondents had relied on the confidential nature of the disclosed documents but had not specified, named, or explained why they were confidential in nature.
So I just follow you that. Could you just identify for me what the disclosed documents as defined are?
The disclosed documents, they were documents which had been disclosed in the Cypriot proceedings. As I referenced in my written submissions, there were Cypriot proceedings which were commenced in 2015 by my client and the members of his family as beneficiaries of the trust, which alleged fraudulent breach of trust, amongst other things, against Ms. Haradimou and the trustees of the Cyprus trusts. In that context, my client had sought some disclosure of documents, and Mr. Pardy deals with the disclosure in Cyprus in some detail in his witness statements, but essentially documents were disclosed. There was an issue, certainly my client believes that the disclosure in the Cypriot proceedings was not as full as it should have been. But the point
I'm just wondering whether you could help me. It's obviously being used as a defined term.
It's defined at page 111.
Thank you.
Bottom of the page. It refers to 54 items disclosed by Ms. Haradimou
Nice.
in Annex A of her disclosure affidavit, whatever that is.
I'm grateful, my lord. So there's no evidence, just as there was no evidence before the Cypriot court, there was no evidence, there is no evidence before this court.
Can I just see where that takes you? At this stage of the forks in the road, this is your alternative argument, that if 46 does apply, then the general rule in 46(1)(2) is displaced by the circumstances in 46(1)(3). One of those circumstances being you're now submitting that there was no confidentiality in the documents, and therefore those factors in Motley Fool don't arise. Would the evidential burden be on you to establish that that was the case in order to bring yourself within the displacement rule?
My Lords, in my submission it would not. It's for the party seeking to allege that they withheld disclosure or did not want to give disclosure on the basis of some confidentiality obligation to identify what the relevant obligation is, who it's owed to, and in respect of which documents.
But they wouldn't be doing that. They would be saying, this is a case which is governed by Rule 46.1. The general rule is the rule in 46(1)(2). Full stop. And if nobody said anything further about confidentiality, then that would be the position. The general rule would apply. So is it not for you to say, here are the reasons why the general rule is displaced?
My Lords, that was never an argument that was raised at first instance. Had it been raised, then perhaps some evidence might have been put forward, but it
wasn't raised, sorry to interrupt you, it wasn't raised because you took your stand fairly and squarely on the basis that 46.1 didn't apply. And this wasn't put forward as an alternative argument. If it does apply, then there isn't any confidentiality. That simply wasn't a point that was raised on your side, judging by the skeleton argument.
Well, my Lord, one only gets to confidentiality if it's an argument, if it's an issue at least, which is raised by the other side. My learned friend has spent some time this morning developing his submission that confidentiality is an argument which ought to be taken into account. Very detailed submissions by reference to total ease and to the 5 factors which are listed there.
He has, and I can understand you saying, insofar as he doesn't rely on coming within Rule 46.1 and says this is just a matter of a general principle. It may be that all these are therefore part of his case as to how the general principle applies, and the burden would be on him. But at this stage of your argument, you're seeking to run an alternative on the basis that his alternative case is right, i.e. it does come within 46.1. And I'm just pressing you slightly on why, in those circumstances, the evidential burden wouldn't fall on you to come within the displacement rule.
Well, my Lord, it's not clear, or at least it wasn't made clear at any stage before Mr. Justice Jacobs, that confidentiality might be a ground on which it was reasonable or perhaps unreasonable to withhold disclosure. If the trustees want to say that they were entirely justified and it was entirely reasonable of them to dispute the court's extraterritorial jurisdiction because of confidentiality, and that is the positive case which they now run before this court for the first time, then that's the argument that I have to respond to. Were it ever suggested, had it ever been suggested previously, that the trustees were withholding disclosure because of confidentiality concerns, then that is perhaps something which could have been addressed, but that was never an argument which was advanced, and indeed it would have been almost impossible for my client to be able to identify relevant confidentiality obligations, the persons to whom they were owed, the documents in respect of which they might be owed, because my client has no idea what particular documents are on Forster's file which form the basis of this application. He sought clarification from Forster's, he sought clarification from the trustees and their solicitors. Indeed, Mr. Justice Robin Knowles was critical of the fact that there had been no cooperation in at least trying to identify the ambit of the documents in Forster's file, essentially leaving my client to grope around in the dark and guess as to what might be there. Further correspondence has since ensued, and again, no further information has been provided. So my client does not know what particular documents or even categories or classes of documents are there, for the simple reason that neither Forster's nor the trustees have been willing to cooperate and provide him with at least that much information. So in those circumstances, it would have been impossible for my client to engage in an exercise of trying to identify the persons to whom obligations of confidentiality might be owed, under an unknown system of law in relation to unknown categories of documents. And in my submission, it is for the trustees, if they want to say that they fall within the scope of these 5 factors, and that is the positive case that's now advanced, it's incumbent upon them to show that to be the case.
Thank you.
My Lord, I see the time is marching on.
Well, it is marching on. In fact, it's marched beyond the time allotted for this appeal, and we haven't had Mr. Mott's reply. You must leave him at least a few minutes to do that, so probably you need to draw your submissions to a close.
Indeed, my Lord. Well, the short point coming out of the factors the trustees rely on is that there's no evidence to say that there is any confidentiality, and none has been adduced, none was before the judge at first instance. And finally, I'd just like to invite the Lordships to take a step back and think about what happened in this case. This was not a case where the trustees came before the court or even said to my client, look, I'm terribly sorry, but I cannot disclose these documents voluntarily because I owe confidentiality obligations. I might be exposing myself to some liability. That's not what happened in this case. And indeed, the usual case where costs are ordered in favour of the respondent is a case where the respondent says, look, I'm sorry I can't help, but I'm not going to oppose the application. It's not the only case where costs are ordered in favour of the respondent, but that is by and large where costs are ordered in their favour. I'd like to show your Lordships very briefly just that point in the Jofa case on which the trustees rely. It's cited in their skeleton argument, the authorities bundle tab 8, page 159. Paragraph 31, where the Master of the Rolls, Lord Justice Legate as he was, said this: while accepting that there can be no absolute rule in the matter, I find it hard to envisage circumstances in which it would be just to award costs against a respondent to an orthophonical application who, before agreeing to disclose those documents, has done no more than require the applicant to satisfy the court that such an order is appropriate. That's the ordinary run of cases where the court does not want to penalise an innocent third party. But that's not what happened in this case. Instead, the trustees have resisted tooth and nail coming before the English court so as to deprive my client of the opportunity to obtain an order for disclosure against them. And when they were brought before this court, they sought repeatedly to delay determination of that application, and they appealed the issue of the court's extraterritorial jurisdiction all the way up to the Supreme Court. So it's not simply a case of standing by and saying, I'd be very happy to comply if you can get an order, and I'm not going to oppose it. And very finally, I'd like to take your Lordships to the Cartier case in which the trustees rely. That's in tab 7, page 146. Paragraph 38, where Lord Sumption said this: intermediaries very rarely resist website blocking orders, although they do insist that the claimant should obtain an order in order to protect themselves against regulatory restrictions and interfering in network communications and complaints by third parties on various grounds. Practice in such cases should normally be to award them their costs of action. In this case, Mr. Justice Arnold awarded costs against the ISPs because they had made the litigation a test case for jurisdiction to make the order at all and had strenuously resisted the application. In the circumstances, he was plainly entitled to exercise discretion concerning the costs of the litigation in the way that he did. My Lord, that principle applies with even stronger force when one is looking at the costs of a separate jurisdiction application. Unless I can insist any further, those are my submissions.
Thank you very much. Yes, Mr. Mott, anything in reply?
My Lords, I have, I believe, 6 points, all of which are brief and 2 of which are simply giving you references. So I will be as rapid as I can. The first point is I'll just pick up immediately on the last point that my learned friend made, where essentially he was drawing attention to the fact that sometimes a respondent to applications such as this simply requires an order to be made, but doesn't positively oppose it. and the answer to that is simply the SES contracting case, paragraph 17, which I showed you earlier, which makes it perfectly clear that reasonable conduct in response to an application includes not just being neutral on it, but also includes reasonable opposition to that application, and that falls within conduct which would still allow a respondent to recover their costs. So that's the simple answer to that point. My second point, my learned friend addressed you in detail on the difference between rules of jurisdiction and rules of substantive law. But in my submission, he didn't suggest a good reason for why the costs analysis of what has happened must always and invariably differ in their treatment of those two things. Because the reality of the situation is that the jurisdiction challenge was one of the reasonable bases on which the trustees resisted the application. The issue arises because Mr. Gorbachev sought an order against foreign non-parties in relation to documents held by their solicitors within the jurisdiction. He did so because he was clear and expressed that he did not wish to follow the usual letter of request procedure under the Hague Convention. And he expressly sought broader and less particularised disclosure than I believe he accepted the Cypriot or English courts would permit pursuant to the letter of request procedure. The trusts are governed by Cypriot law, the trustees are in Cyprus. The issue that arises manifested itself in two ways. The first way in which it manifested itself was the jurisdiction challenge. The second way in which it manifested itself was on the substance of the disclosure application, in a submission that the application should have been brought in Cyprus, not here, because it was admittedly designed to cover documents which the Cypriot court would not order. But in my submission, it's an overly formal distinction to say that the trustees could make the latter point without being at risk on costs, but could not make the former point without having to bear the costs if it ultimately failed. It was reasonably made but failed. My third point is that a learned friend observed that there's no case on how the costs of the jurisdiction issue arising in the context of a disclosure application against a non-party should be treated. I mean, that's quite right. That's why we're here today. But what I've sought to do is extract points of principle and the underlying rationale for what the courts have said as to those costs of the substantive application, that in my submission points the way towards the correct answer and the correct treatment of the jurisdiction issue in this case. My fourth point, and this is where I can just give you the references, but my learned friend seemed to I think doubt more seriously that there was the ability of Mr. Gorbachev to recover the costs of these third-party disclosure application in the main proceedings from Mr. Guriev, even if Mr. Gorbachev was successful. I took you to the Anglos and Kent case in paragraph 6, and if you continue reading through paragraph 6, 4 or 5 lines after the learned friend stops, then in my submission the costs of the third party are dealt with clearly, and it is clear that Mr. Justice Lindsay is of the view that those costs can be borne by the appropriate party to the main proceedings. I should also give you a reference to the Jofa case, which my learned friend took you through to on another point, but that's at tab 8, and at paragraph 35 of that case. I don't need to take you to it unless you'd like to go. It's Jofa and Benhurst, paragraph 35, and the final few lines. Lord Justice Leggett said, it's relevant in that regard that the party from whom disclosure is sought is ordered to bear its own costs, or even to pay costs incurred by the applicant. It has no means, brackets, unlike the applicant, close brackets, of recovering those costs from the wrongdoer. And so I just wanted to provide that.
That's in the Norwich Pharmacal context.
That is in a Norwich Pharmacal context, right? But nevertheless, as a matter of cost practice, those words also assume that the costs of a non-party disclosure application, in that case a Norwich Pharmacal, could be recovered in the main proceedings. My penultimate point, my learned friend took you to Forster's 4th of June 2021 letter, where essentially it was offered to look through Forster's file to try and identify documents which the trustees might be prepared to disclose. For your reference, in the additional bundle which compiled the materials filed with the court last Friday, at tab 3, so that's the exhibit to my further submissions. Again, we don't need to go unless you'd like to go, but there's 2 letters at pages 75 to 76 and 77 to 78, both letters from my learned friends instructing solicitors. And essentially what happened in a nutshell was they rejected that offer out of hand. And they said, no, we want the entire file. And then they issued their application, I think, a month or 2 after those letters. In fact, I think it was even more shortly than that. In other words, the express basis of this application was we want a broader category of documents than the trustees may be prepared to disclose. And my final point, my lords, the issue of discretion, as my learned friend tried to characterise it, was raised. My case on this appeal is that the learned judge fell into error by not applying or taking account of the general principle that I've sought to take from the authorities this morning. That principle was at play. It should have been taken into account, and in my submission, your lordships are in a position to do that, to make the appropriate cost order to exercise that discretion afresh. The SES contracting case at paragraph 24 provides guidance at Court of Appeal level on precisely what sort of conduct is considered to be so unreasonable that it will deprive a respondent of its costs and indeed require it to pay the applicant's costs. But in answer to a question which I believe my Lord Justice Dingemans addressed to my learned friend, it would be open to your lordships to substitute an order for no order as to costs, and indeed I said that in the final paragraph of my Skeleton argument. Those were the 6 points I wished to deal with by way of reply, and a second assist the court further.
Thank you very much. Well, we're very grateful to both of you, and indeed to those who sit behind you as well, for your assistance on this interesting costs point. We will reserve our judgments. They will be sent to you in draft in the usual way, and we hope and expect that you will, in the light of them, be able to agree an order or us to approve. If you find that you can't, we will have short submissions on any points in issue and determine those without a further hearing. I expect everybody in court knows this, but I would like to emphasise the confidentiality of the draft. You will know about Counsel General for Wales and the seriousness with which the court would take any breach of the embargo until the judgment is formally handed down. That concludes the hearing. Thank you very much.
All right.